and gentlemen, esteemed members of the media, and my fellow citizens, I stand before you today with a profound sense of gratitude to be the Sri Tanjung candidate for star in the 2013 general election. Thank you for joining me here on this momentous occasion. It is an honor to be on the stage, surrounded by individuals who share a commitment to the betterment of our community, our district, and our nation. Your presence here reflects the importance of the democratic process and the role the media plays in ensuring transparency and accountability. Vote for me, everyone. Thank you so much for your support. Why am I always on my own? My father, then my son. Now I have to support both of them. Now they are all sick. What about me? Ah!
Very pain, just like my heart broken when my girlfriend.
Hi, I'm a certified doctor. If you can hear me, please open your eyes. Can you hear me? Can you hear me? I announced the death of 4 victims and 1 is severely injured. Yes, hi. I hope your day is fine. I need to perform a blood test on you. Please put your hand here. Cepat! Cepat sikit.
Cannot.
Cepat sikit.
Why?
Don't waste my time.
I don't want. I'm not drunk. Wait, I'm not drunk. The sanitize or not?
Right, it's all done. Thank you.
Regret lah. Should have drink lah. Why I so stupid? Now my father, now my son, no one to take care of them. Why I do this to myself? Why I do this to them?
Alright team, we have a lot to do. This could be the turning point for our client, so we have to be meticulous in our preparation. So now, let's analyze the key issues for our case.
The first issue, it revolves around the acceptance of evidence from the medical officer without producing the required certificate. Do we have grounds to challenge this?
I believe that we can argue that there was a mistake in fact and law. The session court judge may have overlooked the necessity of presenting their certificate, and we need to capitalize on that.
What about the document signed and certified by the government medical officer? Is that crucial for the prosecution case?
It appears so. We need to establish whether the absence of this document weakens their case against our client.
Moving on to the Kubata Wangka part, can we argue that the uneven road is a contributing factor to the accident?
It is worth exploring. We should also delve into the extent of our client's control over her vehicle during the accident.
The session court judge's failure to consider the totality of the evidence is an aspect that we have to explore. We have to ensure that all aspects are thoroughly examined.
Now, the sentence given to our client, is it too harsh? And how about the absence of the motor vehicle's registration certificate? Does it affect the prosecution case?
We can argue that the severity of the sentence needs reconsideration, and besides, the missing registration certificate can create doubt in the prosecution's narrative.
Lastly, the order to disqualify our client from holding or obtaining a driver license. Let's review if it is justified based on the evidence we have. These are all the key issues that we need to work on. I need all this done by 5 p.m. today.
This court has considered the appeal against the conviction imposed by the Learned Session Court's judge, and this court dismisses the appeal. This court believes that the conviction against the appellant is fairly and justly made. The Learned Session Court's judge had applied the correct principles of law in considering the facts and circumstances of this case. On the issue of accepting evidence of a blood specimen without requiring the certificate to be produced by a medical officer, the court holds that the production of the document signed and certified by a government medical officer is not required when the said officer is called as a witness to confirm and certify the blood specimen is taken by him under Section 45, Subsection 3 of the Road Transport Act. The production of certificate is mere directory and not mandatory.
The doctor who took Olivia's blood test, and the result shown that the alcohol level in her blood was high, meaning to say that she was drunk at the moment she drove that day.
On the issue of locus in quo, there is no misdirection in the manner how it was conducted by the Session Court judge, as all procedures had been adhered to and all parties were in attendance, including the appellant. The conduct of locus in quo should be left at the discretion of the presiding judge so long as the interest of the appellant is safeguarded and there was no new evidence arising from the visit. Moving on to the issue of whether the Session Court judge had carried out maximum evaluation of the evidence adduced during the trial, this court finds that although the exact words of maximum evaluation were not used, but the words to the like effect were mentioned when the Session Court judge said, "I had examined the evidence in totality and having considered all these evidences," which suggested the Session Court judge had considered all the evidence given during the prosecution stage and the defendant stage. Whether the absence of the registration certificate of the motor vehicle affected the prosecution's case against the appellant, who was charged as the driver of the car, we find that there is nowhere under the provision of Section 117 of the Road Transport Act which indicates that the registration certificate of the appellant's car must be tendered in court. The production of the registration certificate is irrelevant as the charges against the appellant are in relation to the appellant being the driver and not the owner of the car. Lastly, on the issue of whether the whole jurisdiction of the Road Transport Act shall fall under the jurisdiction of the Magistrates Court pursuant to Section 116A of the Road Transport Act, this court holds that there is nothing under Section 116A of the Road Transport Act that disallows any offence under the Act to be tried in any other court than before a first-class magistrate. Hence, the learned Session Court judge as well could have the jurisdiction to try the same and to mete out sentences according to the law, as the Session Court judge has the competent jurisdiction. There was also no objection raised by the learned counsel for the appellant then when the application for the transfer of the present case from the Magistrates Court to the Sessions Court was made by the learned Deputy Public Prosecutor. To raise this issue at the appellant stage is an afterthought. Based on the above said reasons, we, the court, dismiss the appeal against the conviction. This court has carefully considered the appeal against the sentence imposed by the learned Session Court judge. The appeal is allowed in part. The sentences passed by the learned Session Court's judge, while within the legal ambit, fail to reflect the application of the right principle of sentencing. According to Section 44, subsection 1, paragraph B of the Road Transport Act, upon conviction, imprisonment for a term of not less than 3 years and not more than 10 years, and a fine ranging from Rm 8,000 to Rm 20,000. The appellant had been convicted on 2 charges. First charge, 10 years imprisonment, a fine of Rm 20,000 and disqualification from driving for 5 years. Second charge, 7 years imprisonment, a fine of Rm 19,000 and disqualification from driving for 5 years. The imprisonment sentences are to run consecutively. Reasons for allowing the appeal are as follows. Although the learned Session Court judge has the discretion to impose a sentence of between 3 to 10 years, he imposed a manifestly excessive 10-year imprisonment without due consideration to mitigating factors. The mitigating factors are as follows. This is the appellant's first offence, and she is living separately from her husband, besides her being the sole breadwinner of the family. Its commission is one without intention or not done deliberately to cause the loss of many lives and injury to a person. It was a very unfortunate incident and fated. It was purely an accident that was not foreseen by anyone involved, including the appellant. Medical prescription expense is borne by appellant for her son who has severe tonsillitis and a father who was diagnosed with diabetes mellitus, hypertension, ischemic heart disease and unstable angina. The appellant had taken measures to limit her alcohol intake around 3 hours before the accident happened. The road at the Kubuta roundabout was not in a good condition. During the period of investigation, the appellant had given her full cooperation to the police. The accident also affects the lives of the appellant and her family and friends. She had to quit her job as an executive at Perdana Club due to pressure from the public and had to move out of Tawau to find another job. A job is of importance to her as she needs to support her family. Lastly, the appellant had also expressed remorse as to what happened and sought for an apology from the deceased family before the Honourable Court.
Don't worry, it looks like things are going to our way.
The learned Session Court's judge only gave public interest his most consideration and failed to take into account mitigating factors raised by the appellant through discussion and analysis in the grounds of proceeding, apart from saying he had considered them. He did not manage to strike a balance between public interest and interest of appellant in passing the sentence. The court reduces the imprisonment term for both charges to 8 years and 6 years respectively. Monetary sentence imposed by the learned Session Court's judge for both charges will remain the same as they are within the range in accordance with the law. Imprisonment terms for both charges will run concurrently as the offences in the 2 charges arise from one single transaction. The court affirms the order to disqualify the appellant from holding or obtaining a driving licence for such period as ordered by the learned Session Court's judge.
Better than no change of sentence at all. We should be grateful.
Thank you.
Hey, good one at court today.
Hey, you too. The case today was horrible. Huh?
Yeah, it's unfortunate for everyone involved.
Well, Mom, we should not do and why?
Anyways, are you guys up for a discussion? We still need to work on our submissions for our next time.
Alright, let's go.
Do you think which other cases to compare it to the Olivia case?
Yes, we used public prosecutor against Xu Jingzong and we used R and Cooksley. In public prosecutor against Xu Jingzong, the facts are on March 22, 2017 at 2:30 am, the accused drove under the influence of alcohol and drugs type MDA and MDMA and collided with another car, causing the driver's death. The accused was then alleged under Section 44, Subsection 1 of Road Transport Act 1987. The similar parts of these cases are the accused submitted to the court that there was a gap in the chain of evidence for the urine and blood tests, therefore it was not safe to accept them as evidence. The accused argued that the fatal accident was caused by the MRT project works on the road which obstruct the traffic, and the deceased car stopped abruptly due to the same. The accused hit the deceased car because of the sudden stop and the situation could not be prevented. The judgment in the case of public prosecutor against Xu Jingzong, defenses of the accused person was rejected. Firstly, the accused admits he drank 3 to 4 glasses of beer, which does not support his first defense. Secondly, the court did not accept the second defense. The prudent rule is to drive in a safe distance with the front car, even if the deceased vehicle had braked in a great sudden and the impact of such collision would not have been that tremendous and horrific as seen in this case, resulting in the victim's death. The accused was sentenced to custodial sentence of imprisonment for 42 months from the date of conviction, fine sentence of 9,000 ringgit in default of payment to a further 6 months of imprisonment, and order of disqualification to apply motor driving license for a period of 5 from the date of conviction. Then when we analyze the cases, we can see that both courts do not accept the argument on external factors. In the Olivia case, the court held that if the accused was driving only 90 km per hour, it was unreasonable to believe the car would be easily out of control beyond the opposite lane to the parking bay and cause such a tragic accident. The reason of not accepting the defense on blood tests between both courts is different. In Olivia's case, the court did not accept the defense on the blood test because the document signed and certified by the government medical officer was not needed when the officer was called as a witness and certified that the blood specimen was taken by him. Both accused persons argued that they did not take alcoholic drinks and take only a tiny amount. In Olivia's case, the accused stated that she only drank 1 bottle of beer, but the court refused to accept because the accused did not call any of the friends and customers in the club with her. Therefore, this defense was a made-up story. In Chew's case, the accused first stated that he only drank tea, then admitted that he drank 3 to 4 glasses of 300 ml beer. Although there were slight differences in the reasons for rejecting the defense presented by the two courts, overall the defenses raised by the accused and those rejected by the court were similar. In the end, both defendants were convicted. Another case we can compare is R and Cooksley and others 2003. Although the accident has caused 4 persons died and 1 injured, but the facts and the nature of the offence in the present appeal does not involve any intent to injure, as no one had expected the multiple deaths resulting from the accident. The fact that the consequences of dangerous driving are particularly serious is a relevant factor as to the length of the sentence. However, sentence should not necessarily be multiplied according to the number of persons who lost their life, but should regard the offender's culpability in relation to the driving as the dominant component in the sentencing exercise. The sentence must remain proportionate to the nature of an offence, which does not involve any intent to injure.
Actually, that's really interesting.
Thank you. I believe that your submission on other jurisdictions regarding similar cases was really smart. Do you care to explain more about that?
Sure.
In the UK, based on Road Traffic Act 1988, Section 3, Subsection A, if a driver kills someone while driving under the influence of alcohol, the maximum prison sentence is 14 years. Next, based on Road Traffic Act 1988, Section 1, Subsection A, if a driver seriously injures someone by dangerous driving, the maximum prison sentence is 5 years. As can be seen, the sentence for death is much more than Malaysia, which are 10 years maximum, while the sentence for injury is lesser than Malaysia, which are 7 years maximum. In Singapore, based on Road Traffic Act 1961, Section 64, Subsection 1 and Section 64, Subsection 2, Paragraph A, in cases where reckless driving causes death of another person, the penalties upon conviction include imprisonment for 2 years to 8 years. Repeat offenders may face imprisonment for 4 to 15 years, while serious offenders and serious repeat offenders could receive additional imprisonment for 1 to 2 years and 2 to 4 years, respectively. In addition to the primary imprisonment, as can be seen, Singapore maximum year is only 8 years, which is lesser than Malaysia. This might be because they take into account that most death caused by drunk driving is accidental. Hence, they might be more lenient to first-time offenders so they can learn their action. However, repeated offenders get more years added to their sentence, which makes sense since they keep repeating the same mistake and deserve no leniency. Singapore is also strict with their road fines, which aims to prevent these types of incidents to happen in the first place.
Interesting. Hey, have you guys heard that this case has already impacted on other cases?
Really? What cases? They are super fast.
Yeah, the cases are Pendakwa Raya lawan Darwin Raj and also public prosecutor against Mohan Rao anak lelaki Nachana.
Can you explain more about them?
Sure. In the case of Pendakwa Raya lawan Darwin Raj, the judge cited the case of Olivia Chong to determine the elements which need to be proven for the purpose of charge under Section 44, Subsection 1, Paragraph B of the Road Transport Act. Based on the precedents set by the case of Olivia Chong, the judge stated that the elements which need to be proven by the prosecutors are: accused must be the one driving the motor vehicle that caused the accident, alcohol level in accused body must exceed the prescribed limit, which is 80 milligrams of alcohol per 100 milliliters of blood, and the driving of the accused is the cause of death of victims. In the case of public prosecutor against Mohan Rao anak lelaki Nachana, the judge stated that the case of Olivia Chong served as a guide on the elements that must be established by the prosecution to secure a conviction under Section 44, Subsection 1, Paragraph B of the Road Transport Act. It is very clear that both cases have used the case of Olivia Chong to establish elements which need to be proven for a charge under Section 44, Subsection 1, Paragraph B of the Road Transport Act. It can be said that the case of Olivia Chong has set precedents and is rightly followed by the authorities.
Not only that, but I heard that new laws have been developed since this case.
Yeah. What are those laws?
The laws are related to the Road Transport Amendment Act 2020. There was an amendment to Section 44 of the Act. Subsection 1 was substituted with the following sections that states that any person who drives a motor vehicle on a road or other public places is under the influence of alcohol and cause death of any person is guilty and will be punished with imprisonment for a term of not less than 10 years or not more than 15 years, and fine not less than 50,000 ringgit and not more than 100,000 ringgit in case of second conviction. Imprisonment of a term of less than 15 years and no more than 20 years, and fine not less than 100,000 ringgit and not more than 150,000 ringgit for the driving under influence and causing death. In following subsection 1A, it states that any person who drives a motor vehicle on a road or other public places is under the influence of alcohol and cause injury or any person is guilty and will be punished for imprisonment for a term of not less than 7 years and no more than 10 years, and fine of not less than 30,000 ringgit and not more than 50,000 ringgit in case of second conviction. Imprisonment for a term of not less than 10 years and not more than 15 years, and fine of not less than 50,000 ringgit and not more than 100,000 ringgit. By inserting after subsection 3, the following subsection 3A states that a person convicted under subsection 1A shall be disqualified from holding or obtaining a driving license for not less than 7 years from date of conviction, and in case of second conviction, be disqualified for 10 years from date of conviction.
Thank you everyone, it was really helpful.
Yeah, it was an insightful discussion.
No problem, I enjoyed it too.
For the time, everyone, thanks for today.
Yeah, see you guys tomorrow.
Bye.